All right. Yeah, I think we're recording. I don't know if we're recording or not. This is the first time I've been able to use our new setup in this room. Yeah, so I would hope that the process here for receiving comment on process doesn't interfere with either the first year filings that need to be made, regardless of whatever we're able to put into a rule. So if mid-August is your target, mid-August is fine.
Okay.
Well, besides the plan itself, are you planning on submitting pre-filed testimony?
So no is the short answer, because it really isn't contested. We do have a fairly robust, I think we're working on an application or a notice that will go with it. Again, we really are thinking about this like the IRP. I mean, that's really that was the process that was envisioned as we went through the legislative process. So,
sure.
And that's really what we're envisioning.
Okay. I think I hear his voice.
So, yeah.
Sure.
Good morning,
Sure.
Commissioner.
Good morning.
This is the way it's been all morning. I apologize.
That's all right. Good to see you. Everybody told me you guys were going to be all dressed up today, so I even put a tie on.
This is
Mr.
it.
President.
All right. President Mueller, we're recording.
Okay.
So just so you're aware. Our all party notice.
You did get dressed up.
Yeah.
Did you give your own eulogy today? Or
I did. That's funny. I did find a funeral card in my pocket, actually. So, yeah. Well, I appreciate that. Well, this is kind of weird. Should I go? I'm going to go sit over there if that's okay. So I'm not,
Totally works.
However you're coming.
Yeah.
I'm not looking back and forth playing tennis while we're doing that. There we go. Is that better? There we
I
go.
think that works.
I appreciate you setting up the meeting. I sensed during last week's public meetings that you were annoyed with my response to your letter.
You didn't sense it, you know.
Yeah. So I wanted to come back and kind of talk about that letter in particular, and then talk about this wildfire process. I've been practicing at the commission for a long time, and so
As far as the wildfire process, I was going to interject.
Sure.
To me, it was so intertwined with 490 and the rate case that to talk about one is to talk about the other. We can't talk about something in the rate case. So I'm not quite sure where you're going to go with it. If Lucas goes like this, then we can't go into that subject if it's already been discussed in the rate case, because that is an ongoing contested case.
Absolutely. And I totally agree. And I've not actually done very much. I'm aware of the rate case. It was, I started, I think, about 4 days before that hearing started. So I have not played much of a role in the rate case at all, other than getting some lunches while we were prepping witnesses during that hearing. So, I guess that's the part where I pretty strenuously disagree. I don't think House Bill 490 has anything to do with anyone's rate cases, nor do I think that 490 review process can have anything to do with anyone's rate cases going forward. And that really is because, I mean, if that were the case, then we're never going to be able to get resolution on wildfire plans.
Well, that's not true. In the bill 490,
Yeah.
you present your plan. We tell you if we think it's, whole or insufficient. You address your insufficiencies, and depending on time frame, you go to December 31st, we're done. That is not in the rate case. But everything about the fire mitigation plan, even though not necessarily, certainly not in the pre-filed testimony, certainly came up in testimony. So it is now part of that record and part of what we have to consider.
Well, respectfully, Mr. President, my understanding is what was presented in the rate case are historical costs.
There were no costs presented. There was several estimates of $8 million a year, one of $7 million a year, and one figure of $300 million. And I don't know where the hell that came from. The one that testified, he said, I don't know where it came from either. So I don't know. The bill says that you have where we are to base our findings of fact on estimates. Well, estimate is not a finding of fact. So the discussion on estimates and costs going forward were discussed in the rate case. To say they're not part of 490 is wrong because it's in plain wording. So I see a conflict. So not a conflict, but a conflict in that this is something we can't talk about. And here's something that we have to act on later, but really can't talk about now, is my view. Lucas can weigh in on that if he wants to. May or may not affect how I think. But we can find some sort of resolution on how we can talk about what you want to talk about. I'm good with it. I'm not trying to be a stick in the mud.
Okay.
So we do have historical costs, test year costs in the rate case. And beyond that, I won't get too much into the historical period. We also have the wildfire mitigation balancing account, right? Which is meant to be a prospective recovery of costs associated with wildfire mitigation, right? So I think
you're talking about the bridging costs.
Bridging costs. So there was a bridge rate that pertained to YCGS, different concept.
I thought there was bridging in the mitigation plan too. In the rate case testimony, we need bridging. I don't know if it's written in there. I'm talking about verbal testimony.
Right. They might have used the word bridge, and I think it's important to not get too deep.
Understood.
That mic in the room, but the wildfire mitigation balancing account, right, could be viewed as a way of bridging the gap between different rate cases and making sure that the utility gets recovery of the costs that they actually incur year to year on wildfire mitigation.
That seems to be the intent of that.
Right, exactly. So it's a mechanism that allows more timely recovery than general rate cases would otherwise allow. So we have a bit of a conundrum here, I think, to President Molnar's point, right? On one hand, we've got historical, that's part of the rate case. Obviously, we're not here today to talk about that. We also have a wildfire mitigation balancing account, which does look prospectively at what Northwestern will spend in the future. We also can't talk about that, right? Because wildfire mitigation balancing account, disputed issue, or at least it's part of the settlement agreement, so it'll be something for the commission to decide. So we're not talking about the cost recovery associated with wildfire mitigation activities when we talk about House Bill 490, right? We can't, it's not intended, as I understand it, from the plain language of House Bill 490, to be a cost recovery statute.
That's right.
It's intended to be a statute that provides the utility liability protection. And in order to get that liability protection, the commission first has to pass judgment on essentially three things. One, does the plan contain all the required elements of Section 2 of House Bill 490? 2, is it in the public interest? And 3, does it reasonably balance the costs and risks associated with wildfire mitigation? So I think the rub, right, as I understand it here, President Molnar, is perhaps wildfire mitigation balancing account, forward-looking cost recovery. And at the same time, the commission is considering whether forward-looking wildfire mitigation plan reasonably balances costs with risks. Is that a fair statement of yours?
I think so. And they did use the word bridging. And not only there, I believe some of the interveners, I think 4 really came out heavy against a bridging mechanism on wildfire mitigation. Mm-hmm. So it's very much a part of the rate case.
Absolutely. And again, I think the way Lucas has differentiated this really well, which is the recovery, right? The cost recovery versus the plan approval. And I understand it's very difficult to kind of segregate those. But let me give you an example of how.
Perhaps you and I disagree on this. And maybe you should know how I think. I don't see it as being, we have this and we have this. We have a final finding that's composed of this and this. That's why we're supposed to look at the estimates. So it's not that we rule on this and we rule on this. It's whatever we do at the end is going to be components of these things, whether accepted, rejected, or modified. So I'm looking at one vote at the end that says by statute that this is a balanced approach and in the public interest. Well, you can't have a $300 million cost versus an $8 million cost and split the, get all Solomon-esque and split the baby. Well, we'll give you 50 million. That's why I need because they say estimates. What have you been spending? Compare that to what your estimates are. Why is this far greater than inflation? What are you doing different? Oh, okay, it makes sense to me. That's in the public interest. Doesn't make sense to me. Why would it be 50% higher? I'll tell you guys been doing for 30 years. So that's where I'm coming from, that I can't discuss with you. Because I don't have the estimates yet. I haven't run them past, and I don't have the historical spending.
Right.
So I can make these comparisons, and until I have them, and staff can look at them, and my fellow commissioners can look at them, I can't talk about it.
So and this is on our website. You're welcome to, I mean, this is a public document from our perspective. The current version of the wildfire plan, we're updating it a little bit to fit within the kind of the formatting. We feel like we'll address 490 a little bit better, but it's a tweak, not a redraft. So, I mean, we have in our current plan draft, we have our estimated cost numbers, and we show kind of our spend historical, the estimates, and then our projected going forward. And we're projecting in 2025 that we'll be at about $63 million. And then in 26, we're going to get to about $81 million. And then it kind of levels out on a go forward
new expenditure, because it's not like you just started vegetation management plan. So what I don't want, I so hate getting calls and want to speak to the owner of the corporation. So, I'm willing to take a look at those, but I would have problems finding that historical spending is an estimate. It's got to be a number.
So yes, I mean, those are, and you can see that. So in 2023, we had an actual incremental of 2023 and 2024 are actual numbers in our plan. And then we've got budgeted and forecasted going forward. So 2025, we're already in that budget year. So that's a hard budgeted number. And then 2026 forward in our plan is a forecast. That's where we are wanting to get. So I'll just talk through this with you. The way I view this is, and I come at this from, again, the liability side of this, the liability protection side of this. The whole goal of this is that if the commission thinks that Northwestern Energy's forecast of 81 million is either too high or too low, you can provide us that feedback on the front end. We will then adjust our plan and come back and give you a number that we think meets your expectations, and you can approve our plan at that point. Now, if we come in and we've spent $81 million buying people fire extinguishers, and that's what we try to come in on a cost recovery, I would expect you're going to say no to at least some of that expenditure, right? So this is what we talked about at the legislature and what we talked about in the session last week is this is directional, right? This is the commission directing us to do something. What we're trying to.
I'm not sure I want to direct you to do anything.
Well, I'm not sure I want you to either, Mr. President, but that's what the stakeholders want. The stakeholders want.
There's a lot of things I don't care about in this world. Stakeholders.
Well, the legislature is one of our stakeholders, though, and the reason this is important.
They're not liable for it. Yeah. To me, a stakeholder and a special interest are one and the same.
They can be, certainly. Yeah.
Okay.
Yeah.
It's not my job to placate or listen to special interests. My job to look at the numbers. It's my job to okay your plan even if I don't want to. I do not think it's my job to say $8 million in line inspections. I can just turn Benochi loose out there and he'll tell you to get carbon core and I'll save the entire inspection thing. I just can't save the carbon. If I say another 2 million, is 2 million too high? When the fire starts, and it will, somebody will say, hey, why didn't you okay the higher number? And I don't even know. I have no idea. All that stuff will be up to the actuarial of an insurance company. They're the experts and they're the ones that have to be happy, not me. I really don't know how to address these things. Lucas keeps saying, and Will keeps saying, well, you know, we'll get around to it in the rate case, and we'll this and we'll that. How about doing it right up front? And I don't know that we can. Because I don't know how many millions we should put into line surveys and where it should be underground because you're getting close to a suburb. I don't know. You know, for me to get into that stuff would require a rate case and have some expert testimony, and we're not gonna have that. Not in a couple of months.
I agree, and I think that's, so our goal is not to have you get into those.
Yeah, and yet you're saying, and I think rightfully so, you gotta give us guidance. So I can't give you guidance without saying something.
Well, right, but no, what we're saying though is I think, I mean, 2 million here, 2 million there. I understand that's a lot of money. In the context of this plan, this is not a $2 million question.
It's not. What I'm saying is you give me numbers and you say, give us guidance. And I say, I think you're 2 million. I think it's 2 million too high. What do you mean fire extinguishers? Why do you get nozzles and give them to the volunteer fire department? That's not my job. Your job is to think it through. I don't know that I have the capacity, and I'm damn sure I don't have the desire to get in there and micromanage your fire management plan because the liability is too freaking great.
Right. No.
And personal responsibility. 5 years from now, I'm looking at body bags filled with mothers melted their children like they find in California, and I wouldn't okay them to me. But you know, this isn't my job.
Well, respectfully, sir, it is now. I mean, that's the legislature has given you this job.
Well, respectfully, what I told Vince Rickey, who chaired the Judiciary Committee, is my senator. I'm the one that convinced him to run. Still hasn't forgiven me. And I sent him a couple of texts and a couple of emails. Let's get together and talk. We got to get it, you know, we got him in your bill. And he never did. So I ran to him in the hall. And I told him that bill is so ugly as far as the PSC goes. If we wind up with a 2-2 vote, and the judge orders me to vote, I'll go to jail for contempt before I vote for that son of a bitch. So there has to be a way for me to not go to jail or I go to jail.
Well, I'm hoping that you're going to love our plan. You're going to agree with the numbers that we have in there, or we're going to have some direct
this
feedback.
conversation is about the numbers I've asked for and haven't got.
So let's come back. I think if we can tie this off just real quick, that we'll come back to that, if that's okay. I mean, that is why I came over. But I do think now that we're down the path here, again, we don't think the commission can or should get into those kinds of weeds in the plan review. There's not enough time. There's not enough. That was not the intent. The intent here is for you to say, yeah, the wildfire risk is real for communities and for customers, right? So for us, I mean, everyone talks about the company's wildfire risk. For me, this is the customer's wildfire risk, right? Because the customers are going to pay our wildfire costs, I hope, if they're prudently incurred, and the customers are going to be responsible for our liability if we're held responsible. They're already paying our liability premiums, right? So our customers, these are costs borne by our customer, whether that's wildfire liability or that's wildfire mitigation cost. Those are costs borne by our customer. And the goal, as Thor Nelson articulated and a couple of other folks did, the goal of the commission review is for the commission to come in and say, hey, we don't want $300 million of carbon core transmission or distribution line upgrades, right? That is not an effective use of customer resources. We hope we'll get you to say, yeah, we think $81 million a year in spend on all of the things that are outlined in your plan is an appropriate balance between the potential risk of a runaway wildfire in our service territory and its impact on customers and communities versus what we're asking customers to pay while we're doing that on an annual basis. Okay, that's the balancing.
Can I give you a suggestion?
Sure.
Okay. I don't like the idea of we got a vote based on your estimates. And I don't even know how the hell the contract was put together to get an estimate. The bids were put together, the RFP was put together. Okay. You've already got your historical. I'm asking for that.
Yep.
Bring to the commission not an estimate for 2027 or 2026 or whatever. Come forward with contracts. This is what our contracts are going to cost us. this is what's in it. That makes far better sense than what they put in there of, we're gonna vote based on estimates. What's an estimate worth? Absolutely friggin' nothing.
Well, the estimates are certainly informed by the pricing that we have.
You're informed by the pricing you have, or me by the contract you wrote for that time period.
And this is where I struggle, because it feels like
The whole
to
thing with this struggle,
but it feels like to me that, if it feels like to me, the contracts are a rate recovery discussion. That's a rate case discussion. What we're trying to avoid, what I would have loved representing a utility, was that this was an advanced prudency determination. That isn't what the legislature approved. I would love for the commission to say, yeah, you go spend that money and we're going to allow you to recover it. That isn't what we got. That isn't what House Bill 490 gave us, right? House Bill 490, again, is directional. It's like an IRP. We can give you comments. You're telling us what you're going to do and we can give you comments. It isn't, yeah, we're going to allow you to recover that resource, or yeah, we're going to allow you to recover that, expenditure.
and that is a pre-approval.
Right.
Every time I use that word, I get shut down. I think it is. I think the second you say it's in the public interest, it's a balanced approach. That's the exact language we need. And I think we're into pre-approval. A year later, this comes up for your bridging or general rate case, whatever. And we say, well, no. And you say, it's right here. It's balanced in the public interest. And you say it's not. No matter how we rule, if you don't like it, we can go to court and you're going to win.
Well, God, I hope that's the case, but I don't, I don't hold out that much hope, Mr. President. I think that the commission always has the ability to go in and look at individual costs and determine the prudency of individual costs. I think, and we have
this background crop, which is put into the bill for a purpose. Wasn't to help somebody make money based on being paid per word written. That was introduced as an amendment on the House side. It didn't go through the committee. It was on the House side. And now we got it. Well, why else would it be there? Other than to say, you've already said, it's a balanced approach that is in the public interest. Now you say it's not.
The reason the commission review is in there.
And I'm talking about those words.
Which words?
Yeah, balanced approach in the public interest.
Oh, I think those were put in the House committee, but I mean, I'm not sure that it matters. I mean, they're
on the House side. And no matter where they got put in, I mean, it's pre-approval language. And yeah, we can always go back when we need pre-approval. We had the judge and intervene and we pre-approved Yellowstone. We can come back and say, overrun this, this, that, and the other thing, blah, blah, blah. But it's a lot more difficult once you're.
Well, and I agree. I mean, the 698202 pre-approval statute is specific, and in those cases, the commission is pre-approving costs. It's pre-approving the acquisition of a resource. That language is nowhere in House Bill 490. This is not pre-approval.
But the concept is, that's my point. We don't want to get into a parsing, nitpicking thing here. That's how I feel about it. I can't be talked out of it.
Okay.
I believe that's what those words do.
Okay.
Nothing, no other reason for it.
Could I jump in here?
Yeah, please do.
So comparing the wildfire mitigation review to the IRP review, right?
Yeah.
The IRP, the Integrated Resource Planning Act, doesn't include any requirement that the commission find that the plan is in the public interest or that it reasonably balances costs and risks associated with the resource investments, right?
Yes.
So when we do an IRP review, our commentary or feedback to the utilities is usually something on the lines of broad strokes analysis or factors that you're considering in the process of the review, not necessarily specific directions as to like, we think you're planning on spending too much on a natural gas plant, or we think that this specific investment in a wind farm is an imprudent investment. We'd rather see you spend your money on these other things, right? Those are not the sort of things that the commission is really empowered to say in response to an IRP, right? Or at least
That's not
We
what
may
the
be
commission has
empowered. Yeah.
typically said. I would agree with that.
We
Yes.
take more of that broad strokes. We want you to consider these, factors as you go forward. If the commission's commentary and perspective on the wildfire mitigation plan was limited not to the specific direction as to dollar figures or specific investments, but rather direction as to the analysis. We don't, we believe that Northwestern should include more actuarial analysis, include more testimony or evidence from underwriting to demonstrate that you've reasonably balanced the costs and risks associated without getting into the sort of direction that you're talking about, as I understand it, which is direction as to specific investments. Do you think that would be a fair interpretation of the statute?
I think the commission could get into the direction and to specific investments. Really, I view it more as, again, directional relative to spend versus risk. I think that's the big issue here is, I'll step back just a second. I mean, the big issue here is we're never going to be able to address all of our risk mitigation in 1 year, right? Because vegetation is going to grow. So this is an ongoing issue, but the bigger issue is we're also not going to be able to even address all of our existing wildfire risk in year 1, right? So the issue here is what risks, right? What level of spend is appropriate for us to get the biggest bang for our buck and address mitigation risk without completely driving all of our customers to economic disaster. That's really the goal. And the reason that's important is in keeping in mind House Bill 490 is a liability protection bill.
Started out that way.
Well, that's how it ended as well. That's the goal.
That's now part of it. That's now part of it.
Right.
Well, the commission became not a advisory or somebody to talk to about it, the same as the NRC is now on
Right.
an emergency. That's how we started. Now you have a rate component tied to risk mitigation for your wildfire plan. It's now very much a two-part bill. That's why we were stuck in there. That's where we got to amend it. We're now major player and finder of fact. That's very different than what emergency services will be when they talk to us. It's very different than DNRC. You've created a whole separate horse in the race.
Except that you're the horse that we've been riding since the inception of the Public Service Commission.
I don't care. It's not where we belong. Your insurance company is where this belongs. For them to be the finder of facts, how much should be spent and what has to be done and all of that, that's really there. You drug us into this. I didn't want to be drug in. You wanted me in the fight. You won. I'm in the fight.
Well, I hope it's not a fight. I mean, that's our goal, is to avoid a fight.
Well,
And the whole point of this is if the commission were to come in and say, no, we think that utilities in Montana should only spend $10,000 a year on wildfire mitigation.
I don't think we would ever make a statement.
I don't think you would either, but if you did,
We're not gonna make a statement, 65 million, 8 million, 300 million. It's not unanimously because I won't vote.
Understood, but my whole point is, if the commission says rejects our plan because it requires us to expend too much and requires us to pull back on what we're spending every year, what House Bill 490 says is, as long as we are following the guidance from the commission, then we have liability protections if a wildfire is started at a location covered by our wildfire plan.
I don't want to spend the whole time discussing that. Because your hopeful outcome is an outcome that I, as a single commissioner, will never vote for. And I don't even see it as being part of the bill. Bill is, we take a look at what you offer. We say we like it. We say we don't like it. If we say we don't like it, you then can modify. And depending on how much time is left, maybe we'll comment on that. And then maybe you'll remodify. But on December 31st, we're done, and it is now a balanced plan in the public interest.
So, but I'd like us to have a 12/31/2025 deadline, but I want to be clear and in fairness, in the interest of candor. The December 31, 2025 deadline is for utilities to submit and begin implementing their plans. That is not the deadline for commission approval.
No, we'll get into it later on. But at that time, my plain reading of this is that you offer a plan. If we like it, we say so, we're done. If we see that we would like to see something change, we can't tell you good. We tell you, and you decide you want to do it or not do it. If you don't do it, then we probably don't have a balanced plan in the public interest. When December 31st comes, this bill and our requirements, and it's start up again, we bring a general rate case, or if we put this thing on the tracker or one-year tracker, whatever we do, they're now going with whatever ended on the 31st.
That's not how I read the bill. Is that your understanding, Lucas?
I'm gonna have to go back and double check deadlines, but before we get to that, 2 points that I'd like to try to discuss if we can.
Yep.
First, President Mueller is speaking in terms of findings of fact, which I think is a salient procedural question here. We can't make findings of fact without evidence. So at the end of this, the commission's final order is written in terms of, a general discussion, but not findings of fact, conclusions of law, right?
I agree with that, yes.
Yeah. So the commission's final order, because it doesn't make findings of fact, those findings of fact don't bind the commission in future proceedings. They don't exist, therefore they don't bind the commission in future proceedings. Okay. So that's thing number one. Thing number two is you've talked about, the commission's approval of a specific level of spend. Do you see the commission's approval of a level of spend as an essential element of giving utilities the protection envisioned by House Bill 490? Or could the commission approve a method of comparing level of spend against risk of wildfire and leave our findings, which don't exist, our conclusions in the final order of this process at just that, the same way that we do in the IRP process, right? We're not finding Northwestern, you must build a wind farm with a solar battery of 60 megawatts, right?
Yeah.
That is the level of investment that we expect to see. Rather, we say, when you make your decisions, we want you to be able to demonstrate to us that you've considered all these different factors, right? And that would be the same thing that we would expect Northwestern to present in future, looking only forward, future cost recovery.
Yes.
Whether that's a general rate case or a balancing account. Demonstrate to us that the costs that you've incurred were reasonable to mitigate the risks that you face, right, as a utility.
Yes. And
so if the commission's final decision in this House Bill 490 process is not approving a specific level of spend, be it $80 million, $100 million, or $10,000, right, it's rather, this is the process we expect you to use to evaluate your level of spend against the risks that you incur. Is that a reasonable way of the commission approaching this?
Yes, is the short answer. I think it is. And that's how our plan is laid out. Our plan goes through how we make those mitigation decisions, what that, and that decision tree, and how we decide what, kind of where, and how, and what we're going to do.
Okay. So,
to me, you're asking us to accept your assumptions. That's it. Your assumptions. Been no discovery, there's been no examination, no expert witnesses, other than perhaps the guy we hired, which I demonstrated yesterday. We have no idea who he looks like yet. You assume that this and that, you got your estimates, and you got your all this. You're asking us to accept your assumptions as being in the public good, and I don't think we can do that. Because it's all hearsay. So there's a lot of bridges here to make it across. And by the plain wording of the law, I don't think that I can be convinced that we can make it across all of them.
Okay. All right. So if it's not a discussion, though, of we're approving a specific level of spend, which is, at the end of the day, nothing more than the aggregate, of individual projects, individual efforts, individual investments that you'd be making. And that President Molnar's point, he feels very uncomfortable getting into looking at each one of those without full record evidence, without the ability to make real findings of fact. So if we left the level of spend on the side and just focused on the method of balancing risk, that could work.
It works for, yes, is the short answer. Yeah. I mean, I think that's the, yeah.
Okay. Well, that's something that we should talk about more separately, but I think that's progress.
Part of this is that I'm kind of old crudge and I'm sitting here listening to what you say, and it makes sense to me. And I see you going, yeah, it makes sense to me. I'm looking 5 years down the road when there is no longer Commissioner Molnar, there's a big fire and a judge saying, what the hell do you guys think? You know, we are in a very illiquid, unbalanced structure on this. Nobody came to us and asked, what do you want to do? And I want to do what I can to protect customers and utility and the economy of Montana. And I can't see I can do it in this. So I'm feeling like I'm being, you know, like on the proverbial square peg, and that thing is the round hole. And no matter what we do, and this was at the end of the Senate hearing, in my part of the testimony, is this will be an ongoing wreck. And it will be. How do I know? Lightning will strike somewhere. The grass will be fairly tall. There'll be 40-mile-an-hour winds, and 1 mile in that direction is 10 multi-million-dollar houses. That's all I know. It will happen. A zillion lawyers, they will darken the skies, flying in here to sue. And they'll sue every friggin' body. Not me individually, not him individually. They'll sue us. Maybe we'll get out of it, maybe we won't. And once that's settled, the jury will rule, maybe we'll get out of it, maybe we won't. I'm not saying this is being a type thing.
Okay. Well, I would propose, President Molnar, that we continue our discussion about ways that we can do this.
I'm all in favor of working together to get it to come out. I'm not sure that we're gonna come out on the side of the plain wording of the statute. I would like to think we could. If we do, I don't think you get everything you want in the way of liability.
Well, I hope that what I've posed here, sort of on the fly, bear with me, is a reasonable interpretation of the statute, right? You're still talking about, you know, does it satisfy the elements of Section 2 of House Bill 490? Okay, all right, done. We can evaluate whether or not the plan nominally checks those boxes. We can talk about the public interest, very broad, very general, up to the commission to determine. The sticky widget, as I see it, is that balancing of the costs of the wildfire mitigation plan against the risks of wildfire, right? That is where, on one hand, you could assume that that means that we've got to dive into the level of spend and approve, you know, a range, or, you know, at least in general concepts, the proposal of the utility in its wildfire mitigation plan. It could be about level of spend. Or I would submit another reasonable interpretation of this is the utility using the right analytical tools to compare the level of spend against the risk.
That's a lot to do in 6 weeks.
It's a lot to do in 6 weeks. And as to Mike's point, I do think we're up against a wall here, right? I mean,
who created the wall?
Well, the legislature at the end of the day, right? I understand the primary players in drafting the bill, but the legislature bought into it, and we take our direction from the legislature, right? So,
yeah, but not to get too far off the topic. We had a 5-part rate case that was filed to have a hearing during the session, after the session, and then we did it after the session. And all of this, the time is clicking, and now we've got that to do. We've got final on MDU and a lot of other stuff. And now this, I didn't use it yesterday, I used it today. Northwestern, between that and this, leads me to believe that they have learned to use time compression as a weapon against deep and meaningful probing by the commission.
Well, I'm pretty new, Mr. President, but I think, here's all I can say is time marches on. And I mean, I think that there's all kinds of regulatory mechanisms and devices in Montana that dictate timelines. And so, I mean, I'm not sure that the time compression I'm not sure what you mean by that. We have every faith that the commission will be able to do the job that it's
You know
intended to do.
We'll have 9 guys, we have 6.
We've got 5 attorneys and a paralegal. Will has a team of, might be right on 9.
I think that's what you said yesterday.
Yeah.
Okay, so those 9 people handling a rate case, one issue. Balls to the wall for a year. 5 issues? How many balls you got? They can't all be in the air. He's got people that do small water cases, they do this, they're kind of compartmentalized. He tends to have them specialized. And you get 5 moving, Northern Cheyenne, UVM, natural gas, electric, Yellowstone. The first 3 are pretty easy. So I can do either one of them, do balls to the wall. So you put all these together. I don't know that you guys think far enough ahead for me to say that you did it on purpose. All of them together blow us up for time. You don't have the time for that number of people to handle that level of work. Certainly not in 9 months. Quite possibly not in a year. And then you throw this in, also has a time limit. December 31st. When's the last time you saw a forest fire break out? January 1. Where the hell did that come from? So I'm seeing the impossibilities or the extreme difficulties in this, and the impossibility might be to do a real deep dive, because you guys don't have the numbers yet, at least I haven't seen them. And so if you can't do a deep dive, and there are others that normally would be involved in this, consumer counsel, etc., aren't even involved. We're shackled by the bill that you wrote and got passed. And I don't like being shackled. I'm kind of a free spirit.
Understood. And let me, so I want to go back to the 1231. So the 12, and this is one of the reasons, and we started talking about this a little bit and with Lucas on the submission. Our plan is to try to get this plan submitted as soon as we can this fall. The commission's approval is very important to us, as I indicated in that meeting. So our goal is to get so that we'll be ahead of the rest of the plans. We understand this one will probably get more scrutiny than some of the others. And we also have a second plan that we're going to have to submit by the end of the year for the CTS, the coal ship transmission system. That'll be a much simpler plan. But we are trying to be very respectful of the commission's resources and commissioner and staff time.
I appreciate that.
The 12/31 deadline is the deadline to submit. And I suspect, and I'm confident, you're not going to see the CTS plan. And I think we heard from Montana Dakota, you're not going to see their plan until much later in the fall. So the 12/31 deadline is the deadline for the utilities to submit to the commission. The commission's deadline to consider the plan is triggered by the filing, and that's set out in that with the public comment and the public hearing process. That's that 105 days or whatever. That flows. The 12/31 is the deadline for us to submit, not for the commission to complete its review. So that, again, we are trying to meet our own needs to try to get the certainty that we feel like, or at least the additional protections that commission approval will provide us from a liability perspective, while being considerate of the commission's time and staff resources. So, I mean, that really is the issue. That I think kind of brings us back to the issue with the letter, and your letter presented a couple of issues for us. First, I think I shared with you last week that I've never seen a letter like that from a commissioner, just direct from a commissioner to a company official, demanding production of documents outside of and I've never seen that occur outside of a docket, and I've been doing this for quite a while. So we frankly struggled a little bit with how to respond to that. You don't know me very well, but I have nothing to hide. I have no axes to grind here, but we do have an obligation to try to protect information that we think is going to be helpful and important for us to serve our customers and to meet our obligations going forward. And one of those, obviously, is the pricing and the provisions and all of that of our wildfire vendor contracts. We have no intent to hide that from you. You are statutorily entitled to access that information if you would like. But with this letter, we don't have a docket to put it in. We don't have a context in which to determine what the basis is for the request. And we didn't really have, although I'm probably not as good a lawyer as my former partner Wiley, he came up with a motion for protective order. I frankly struggled with what our basis was, because in formulating a motion for protective order, you have to balance the public need for the information versus the private need to protect that information. As I sit here today, I still don't understand what the public need is to have those documents filed with the commission. Well, so this is, I think, where the disagreement about what the scope of review is on House Bill 490. If, Mr. President, your goal is to go through all of our contracts and to fly spec all of our expenditures as part of the 490 process, I can understand why you believe this to be an unworkable process and an overly daunting process.
I'm not a fly spec kind of guy. If I were, I haven't got the time. Like I said, I want to make sure that your estimates have some correlation to what you've already spent on the exact same similar projects. Most of them don't even really have a cost. Communication. You want to notify people of forest fires coming and we're going to shut down your lines? Call the sheriff's department. They already know. Call them. Say, I'd like to issue this. It doesn't cost any money. An email list, a text list of customers out there. They might not check their email. They might not check their text. We understand that. Sheriff knocks on the door. They're sick in bed. They didn't hear him. There's going to be people probably there. That doesn't cost you real money. Energize, de-energize. When I asked them about that specifically in the case, public record at this point, they said, "Oh, we know how to do that. We wrote for plans 2 years ago." So there's no real money there. It was a friggin' meeting in the mines in a conference room somewhere. And I'm sure the people that know how to do that were the ones that made the final decisions. If your enhanced vegetation plan is suddenly $10 million more this year than last year, I would ask why. What went wrong last time? Did you get a forest fire out of this? Because I can't live with estimates not knowing what's already being expended, and then you get into a rate case and all of it is in there, and this is already in there, you're double up. You got a contract with Joe's vegetation company, vegetation removal. Fine. How'd you do that? Well, we awarded it to him. What do you mean? Did you get any bids? Well, no. Why? Because his mother's maiden name was Bird. I don't want to hear about that shit either. Go through what you have. There's not that many counties that you have a line in. I don't think it's that big a deal. You already have them. The letter was very specific. The things you've already done is what I'd like to have first. What you intend to do, you can play with for a while, but we're a very, very short time frame here. I would like to see these. And then I'll write out what I want. I'll look for them. I'll turn it over to Will. Say, this is what I look for. Do you see I missed anything? Am I misinterpreting that? It's not the kiss of death. It's how real businesses run.
And what are you going to, that's okay. And you were certainly entitled to see that. I don't understand how that comes into 490.
I thought you explained it, but maybe.
So what you just explained to me is a rate review.
But no, because we have to make our basis, our determinations, including your estimates. That's in the bill.
We have to include our estimates. That is correct. Yes.
Okay. So why do I care about your estimate if I don't know where it came from? You can lowball that. Oh, well, had a wet year and the dandelions grew. We had to fly around and spray Roundup underneath our line. I don't give a rat's ass. How much did you spend? How much do you think you're going to spend? And you can explain your overages later. But in the meantime, I'm not going to okay something and get blindsided in a general rate case or a interim rate case. But I don't understand why you would fight back even if you don't understand it. Let me play my silly little game. I was in business 34 years. I handle hundreds of millions of dollars. I know how to look at your contract.
I'm not, I'm certainly not challenging your ability to look at a contract. What I'm trying to understand is how that feeds into this process.
Because we have to base it on your estimates, and I'm saying I want an estimate that's founded in fact. That's what-
You want to compare the estimates that Northwestern will be submitting with its wildfire mitigation plan
to
with
their
the
historical-
actual costs.
that they actually have incurred thus far.
Right.
The exact same thing, as far back as they want to go.
Yeah.
I'm damn sure they've been doing vegetation management for a long, long, long time. I don't want to go back to 2002.
Right. So Mike, is that a reasonable enough?
I mean, we can file a motion for protective order and we can provide the contracts. I'm not sure how those are going to feed in, but I mean,
Trust
the
me.
commission is entitled to
Trust
see
me, if they
those.
don't, it won't. But when I'm looking at an estimate, and you're saying $65 million, I want the estimate based on something that I can rely on.
So there's a lot of detail that rolls up into the estimate.
That's okay, I'm a detail guy, just give me what I asked for, we can move on.
Well, but the contracts are not, the contracts are the contracts. And I mean, I've looked through those, I'm not sure how that ties out to the, yeah, I mean, we can give you the contracts.
And give it to me and I'll show you, then you'll know much more than when you walk in.
Okay. I mean, it's that, yeah, we don't, yeah, okay. I mean, we can work through that process. Mr. President, we need to have, if you want to examine our books, the statute says you get to examine our books, and you can come over and do
And I
that.
don't want books,
I'm
I just want the contracts that you've done to feed into 490.
And I want to follow the law, and I want to provide you what you are entitled to have under the law. This is a difficult conversation. I am not aware of any legal authority for your request. And I want to be able to say to our vendors, we had a lawful request for these documents and we had to provide them. And here are the steps that we took to protect them.
Including a protective.
And that's important because we need to be able to get bidders in the future. We need to have people who are going to
That's why I
contract with
said,
us.
Get a protective order, start gathering your stuff, start your process, whatever you think you need to do. And we'll take care of that. A lot of the protective order stuff to me is more hypothetical than actual. You can feel about how you want to file the order, give me the documents. Let me know.
So Mr. President, who are interveners? Who are going to potentially have access to these?
I don't know if there's any friggin' interveners at all. There's not gonna be a case.
So you're a public agency though.
Hmm?
And once you have those documents, I lose control of them. And frankly, so do you. Once you have those documents, they are a public record, even if they're subject to a protective order. Those are subject to review by courts and they're subject to discovery by third parties who are not us and who are outside of our control. So I take the confidentiality of our business records very seriously.
That's why you should. That's why we have a protective order. I'm not sure it's ever been breached.
It has absolutely been breached and I've been involved in the cases where it's happened.
So certainly if it got breached, attempt to breach, you would have your say. Right now, as you just stated, I'm fully within my authority to request them.
You're fully within your authority to examine them.
Yeah, maybe.
The statute says examine.
Okay, I have requested them. For me to examine them serves no purpose. Because I can't get it to the other commissioners and I can't get it to staff. Okay, so for me to go look at it and get on my little James Bond camera and take, 800 pictures serves no real purpose. If you are going to say no, plainly say no. If you think you can file a protective order, as everybody else seems to be able to, and you seem to be able to, even your final deal on the rate case was partially redacted. You seem to think it's okay for everything except for this request. I don't get it. If you don't want to do it, just send me an email that says,
So, Mr.
with all
Chairman,
due respect, no.
so those are all pending cases. Those are all pending cases with lawful requests for information. I'm asking you if you can tell me, or if you can have your staff, what is the statutory basis for your demand that we produce those documents at your office?
The authority of any commissioner has to look at your documents.
To examine our documents?
Well, it's a lot easier if I can examine them at midnight at my home or on my computer than in your office. I gotta go to 800 of them and memorize them. I think you're building a fairly spacious case.
I want to be able to say that we did our due diligence and this is the commission's
Or
authority.
to make your decision and send it to me. I'm not gonna debate it forever.
I'm not trying to debate this, sir. I'm trying to understand your legal basis for requesting these documents. We don't have an open docket.
I totally disagree that if they are under a protective order, that suddenly everybody in the world's gonna come and look at them. If they do, they have to sign a confidentiality agreement. If they violate that, we nailed their hide to the barn wall. That's it, we're done. In my brief time doing this, I've never seen that happen. Maybe you're aware of somewhere, somehow, that it was not necessarily worthy of protective order, and somebody breached that. I can't help you. If they're worthy, there's a strong process to do it, then we're gonna protect it. Our legal will protect it. Your legal can protect it. And I don't know how many people really give a great big rat's ass about how much you paid for vegetation in Yellowstone County, where there's not even trees there. It's some stubble fields, the ones with broadleaf. It can't be much, and nobody can much care. You don't even have any forests on your transmission line. You got some distribution lines that come out with BPA. Whatever those contracts are, they can't be huge. And they're probably not a secret. And if you think they're secret and you don't want to provide it, just say, sir, we will not provide this. If you want to come to the office of our choice and read these, you can, but each commissioner would have to ask for that individually. And I've never even heard of anything that we did.
So would you agree with me, Mike? We can start a docket with a motion for a protective order. We've done it in the past for tax trackers.
Yes, we have done that in the past.
So
We have a rule that requires us to do that, however.
Yeah, fair enough. Fair enough. We don't have rules yet for this process, right?
And we're not gonna have them because map is too
Right.
slow and you're too fast.
Yeah, so we could, it is not procedurally objectionable in my mind to start the process with a motion for protective order, just like we occasionally start rate cases with motions for waiver of the filing of the specific cost of service study that nobody ever really uses anyway. So we can start a docket with something less than the full application.
I agree with that.
Yeah.
Yes.
So if Northwestern can prepare a motion for a protective order that says we've got how many vendor contracts we talking?
Subject to check about, I think about 25, 26.
25, 26 vendor contracts. Same thing that every utility does when they're trying to protect the trade secret of price terms, other terms that would provide a material advantage or disadvantage to you in negotiating future contracts, right? These are the terms that we believe need to be protected as trade secrets. If they were disclosed, Northwestern would no longer be able to negotiate favorable price terms with these vendors. Therefore, we believe that the merits of public disclosure are substantially outweighed by the privacy interests involved. And the commission can notice that up on the agenda. Yes, we don't have any interveners, but that's why the agenda notice process exists, to have the general public aware of it so they can come in and swoop in like Great Falls Tribune contemplates and object to the infringement on their right to access commission records. When nobody does that, as has been the case, unbroken ever since that Great Falls Tribune case was decided, commission can go ahead and conduct its analysis. I'm not saying that we shortcut the balancing act on our side, but provide that analysis and then grant the protection, and away we go. And that protection could even include special terms, right? No market participants can see this information. MDU can't see this information. I don't know, whoever else. Energy Share can't see this information. Whoever wants to come in, they're disallowed. It's only for the commission to view, or whatever the case might be. Since we don't have interveners in a case like this, I think the universe of people who would be eligible is already very small. But come what may, include special terms with our protective order, or if we didn't adequately anticipate all the different future circumstances, right? You can always file another motion for a protective order. Yes, we had this protection, but we never really contemplated that, who would come in and ask, I don't know.
And hedges.
And yeah, I don't know that Ann Hedges is necessarily the problem here, but you tell me. We never anticipated that Avista would take an interest in this, or the BPA would take an interest in this. So now BPA's intervened. They're not a true market competitor in the sense, but we still don't want them to have access. So here's the new basis for protection. We'll analyze that. We'll protect. Is that?
We can certainly do that.
Okay.
But as we talk through, I just want to make this note, as we talk through the staff's workload and my staff's workload, that's a lot of work.
I understand that. You realize what you did to our staff's workload, and you're the one that put in the time frame. It's not my fault. You've known about this ever since the governor signed it, which was like three and a half months ago. We're still talking about how to get started. That's not my fault either.
We haven't had any conversations about how to get
You need a
started.
conversation. You've got nothing started that I'm aware of.
I'm not sure I follow.
Have you written up your plan to present to us yet?
Yes,
Where is it?
we're planning on submitting it in August.
My point is, it could have been at any time since the legislature signed that and the governor signed that. And you certainly could have gotten it started.
Mr. President, we've been trying to talk to your staff since before the
You
legislature.
don't need to talk to our
adjourned.
staff to put together your own fire mitigation plan.
We have our fire mitigation.
Good.
We need to talk to your
Good.
staff about how to submit it in a way that is respectful of the staff's time and meets the commission's
Put it
expectations.
in an envelope, send it over, we'll let you know. You know how to do it. You just filed a 5 moving part rate case. I'm assuming you can handle plan. I'm not buying the argument that you're busy. We're busy too. We're busy because you're making us busy. And we're gonna do the best we can. I don't think that the last 2 months have been put together very well. To blame me, that your staff hasn't met with our staff. I don't want your staff to meet with our staff. Matter of fact, since our blow up the other day, I've several commissions that are parts of MISO that I normally vote with. All of them like secret meetings behind closed doors. Are you kidding me? I think we're probably the only commission that does it.
Okay. So just one note to toss in here. As soon as they file the plan, then our 105 days starts, right? We got 45 days for public comment, public meeting within decision, public meeting within 60 days. So it's yeah, we'll be pressed as soon as that filing comes in, just to keep that in mind. Whether that's mid-August, whether that was 30 days ago, or 100 days in the future.
We have more to do. Our 1 hour is up. I've got 2 phone calls from the same guy. I'm assuming they're important.
Okay.
Nope.
3.
I think that's fine.
Okay, are we all on the same page here?
I think I understand your position. Yes, I'm not sure we're on the same page, but I
Okay.
understand your position.
Digest what we've done. Go ahead and try and work something out. Maybe we can meet again. It doesn't have to be that long. I'll be back on Monday.
Okay.
All right.
Thank you.
When you say go ahead and try to work something out, are you talking with staff or just internally at Northwestern?
I think he should work something out as to how he wants to present what he wants to do. And bring it to us and say, is this okay with you? And we can say, yeah, except I think, maybe a little here and a little less there, but looks good so far. Present it and we'll
All right.
we'll dig deeper.
And the thing you're talking about there is the full petition application, whatever it's called, for commission approval, right?
Do the proprietary stuff, protective order, all of that, get it started, quit talking about it, do it. You say you're ready to present your plan?
All right. Thank you.
Thank you.
Okay.
You got me out of the meeting. Thank you very much.
Yeah, 1 second. Yeah, I'm not necessarily clear on exactly what the direction is here as for next steps. I don't know that I can provide a whole lot of additional detail under
Fair enough.
circumstances. So,
Okay.
you have what you need, more or less.
I think so. Yeah. I mean, I think we can make some decisions based on this.
Okay,
Go forward.
sounds good. I'm gonna end the meeting.
Okay. Thank you, Lucas.